1045. We now have had the chance to see file number 1044 of 2018. Are you still disputing that this is the personal statement you made to the police on 12th of October 2018?
I want to raise a serious objection. This is a matter 1044-2018 has not been concluded. This is a matter that is alive before another competent court with jurisdiction. Your Honor, my client cannot be cross-examined on matters that are alive before another court. Now that probably the court has allowed us to proceed live, that court might be hearing and watching her submitting there. It is not fair. Your Honor, we object. It can only be mentioned, but she cannot be cross-examined on a matter. This court cannot sit as an appellate court. This court cannot be invited to make a finding of a matter that is likely to also be made a finding from another court. It will be a total embarrassment of the independence of that court and this court. Therefore, Your Honor, we do pray that it can only be mentioned, but she cannot be cross-examined on matters that are alive before your other judicial officers.
Your Honor, I don't know what legal basis my senior, rather my colleague, would have in raising the objection he does. He seems not to have realized why we cross-examine witnesses. We cross-examine witnesses, number one, to test the veracity of the allegations they have made in court. In this case, this court. The law on cross-examination, and we can open it, that's why we spare it is machine of mine, allows witnesses to be cross-examined on prior inconsistent statements. These witnesses come to you claiming to be married to the respondent. She has made a written statement which is filed in a court of law, which was used to obtain release from a court of law, in which she concedes that she is not married to the respondent. That's what I meant last time we were here, Your Honor, that we cannot protect our clients from the truth and justice. Either this witness is lying to this court, or she was lying to the other court. And that's why the law permits cross-examination of witnesses on prior inconsistent statements. Witnesses are also cross-examined, Your Honor, to test the consistency or inconsistency of the positions they have taken on the matter in question. It will be a sad day, Your Honor, a very sad day in the administration of justice, if a litigant can walk to the court just next door, who was before the other court just next door, take a position, get release, cross the corridor to this side, take a very different position, and when they are asked, they say the matter is before the other court. Just for the record, Your Honor, I am not asking the line of questions I'm asking to prosecute the matter number 1044. As a matter of fact, that matter was completed. It is not even true that that matter is still pending. It was concluded. So I pray that this objection be dismissed, because it is an objection designed to enable this witness jump from one court to another saying different accounts over the same issue. And that is trifling with the process of justice. This is too solemn an occasion to be treated like that, Your Honor.
He who comes in equity must come with clean hands. And during the examination in chief, when my client tried to introduce issues of fraud in companies, my good friend was vehemently on his feet, saying that those are matters active before the courts. And the court told us to avoid bringing issues of those companies. What is good for counsel will also be good for me. It is our finding that counsel wants the court to have double standard. If to him some areas are very sensitive and they cannot be mentioned because they are a subject of litigation, this also should apply to this case. Number two, you have been told that the case is concluded. That's not true. There's an appeal. I'm getting the appeal number. There is an appeal pending before the High Court over the similar matter. So, Your Honor, let us protect those matters that are before your brothers and sisters. If counsel had a chance to be in that court, he could have prosecuted that argument in that court. Nothing stopped him from prosecuting that court. He has not raised an issue that there was fair administrative action on the part of the judicial officer to deny him the chance to cross-examine my client. If he has discovered new matter, to reopen that matter and cross-examine my client on that matter. Your Honor, it is my humble submission that matters before other courts cannot, will not be part of a decision before this one. I rest my case.
The direction was that we can cross-examine as long as we remember we are not prosecuting the other cases. So to me, I'm surprised when counsel also says
the plaintiff's counsel has raised an objection in the manner in which the defendant's counsel is cross-examining the plaintiff hearing. It is his view that counsel cannot delve into contents of documents that were made before other courts or before other state agencies. This objection has been challenged, and counsel for the defendant contends that the issues raised in cross-examination are meant to test the inconsistencies of the testimony by the witness. I have considered the objection raised, and the Black's Law Dictionary describes cross-examination as follows: the questioning of a witness at a trial or hearing by the party opposed to the party in whose favor the witness has testified. The purpose of cross-examination is to discredit a witness before the fact finder in any several ways by bringing out contradictions and improbabilities in earlier testimony, by suggesting doubts to the witness, and by trapping the witness into admission that weakens the testimony, unquote. It is clear that in referring to certain documents which were allegedly authored by the plaintiff here, counsel seeks to achieve what has been set out in the Black's Law Dictionary as regards cross-examination. The said documents are contained in a bundle which has since been supplied to parties. This matter was adjourned when it was last in court, so as the witness can assess the said document that has been referred to by counsel. And I find no fault on the part of counsel, and I hold that the line of cross-examination taken by him is in order, and I proceed to overrule the petition.
Much obliged.
Much obliged. Your Honor, I request we adjourn for 2 minutes. I give the instructions.